for me. Um, anyway, I'm really glad to see all of you, and I hope that we'll be able to learn a lot today about what are Native Hawaiian rights and customs within this federal law framework. So I'll be sharing my screen right now. Um, hold on a second. Okay, so what I'm going to kind of cover is what is this sort of special relationship that the federal government has towards Native Hawaiians. And then in terms of protecting Native rights and customs, how does that look like? So there's going to be a melding of uh, different kinds of laws that overlap into federal, state, and county. So I'll try to show like how Native Hawaiian organizations, particularly given that the ONHR, um, serves NHOs and provides resources for our NHOs. I want to begin to kind of show you some of those cognitive links. So we'll begin by kind of talking about where did this special relationship originate? So it was in the understanding that with the illegal overthrow of the Hawaiian Kingdom, there was an acknowledgement by President Grover Cleveland that a substantial wrong was committed against the Hawaiian Kingdom and its citizens, which America must endeavor to repair. Following the overthrow, we all know that there was the annexation in 1898, pursuant to the Newlands Resolution, and then that was followed by the 1900 Organic Act, officially acquiring Hawaii as a U.S. territory. So that included 1.7 million acres of crown and government lands, which they lumped together and called public lands. The revenues and proceeds of which um, were earmarked for the exclusive use of the benefit of the inhabitants of the Hawaiian Islands for education and public purposes. So following that, during the territorial period, Prince Kuhio worked and advocated on Capitol Hill to set aside 200,000 acres of these public lands to rehabilitate Native Hawaiians through reconnecting um, kānaka to Aina in the form of homestead farming. So this act um, reflected some of that trust responsibility, where the U.S. government is realizing that it has to look to to the good of Native Hawaiians as beneficiaries. Um, and so in 1959, the Hawaii was officially ushered into statehood as the 50th state. And under the Admissions Act, there's a clause within there, Section 5F, as the lands are being ceded. It's kind of called the Ceded Lands Trust. And one of the trust provisions was for the betterment of the conditions of Native Hawaiians. So subsequent to that, um, the federal government has passed numerous laws and also included Native Hawaiians in to be similarly protected class of people, of indigenous people, similar to Native American Indians and Alaska Natives. So you have things like the Native American Programs Act, the American Indian Religious Freedom Act, or what we say AIRFA for short, the National Museum of the American Indian Act, the Native American Graves Protection and Repatriation Act. So, I won't go too deep into what these laws are, but, one example is AIRFA protecting the, unique religious freedoms of Native people in America, including Hawaiians. And then NAGPRA is really about the care of Iwi Kūpuna and Moipu, so Native Hawaiian and Native American burials. funerary objects, as well as sacred objects and cultural patrimony. Um, and then there's specific laws for Native Hawaiians, which promote kānaka health and disease prevention. Um, and that's through the Native Hawaiian Healthcare Improvement Act. Also looking to improving educational opportunities through the Native Hawaiian Education Act and providing affordable housing through the Native American Housing Assistance and Self-Determination Act, or NHOs. So some of you may be familiar with some of these different laws, but the main point to take away from this is you have these laws that are supposed to benefit Native Hawaiians. And so that stems from this trust relationship um, that was acknowledged from the time of the overthrow. And this acknowledgement was further stated in the apology resolution in 1993 at the 100th anniversary of the overthrow of the Hawaiian Kingdom. And, there were a lot of questions from this, what felt like a landmark uh, um, resolution by Congress, but there was sort of a criticism as to whether or not this apology resolution um, now prompted certain actions. Yeah, it's not good enough to just say sorry and then that's it. So there were efforts uh, to try and see what does that mean. How do we actually um, reconcile? How does the federal government actually reconcile with Native Hawaiians? So what followed was the Joint Reconciliation Report in 2000 and looking at certain key action steps, some of which have not yet been implemented, but they include the following: maintaining dialogue with Kanaka through the Office of Tribal Justice. This has not happened yet. Supporting the establishment of a Native Hawaiian governing entity. So there have been efforts over the years to try and see if federal recognition is the answer. But in different meetings that the Department of Interior has had in Hawaii about that, it's been a very contentious issue. Establishing an advisory commission for land management, that has not happened yet. What has happened is establishing the Office of Native Hawaiian Relations to address Native Hawaiian issues. So we mahalo ONHR for sponsoring this training, and really the intent is to see how best we can actually, begin to resolve some of these issues. So ONHR provides a list of Native Hawaiian organizations, or NHOs, for which federal agencies consult with on certain projects. For example, NHOs must be consulted whenever a federal undertaking is contemplated. So that's under the National Historic Preservation Act, where if there's any historic properties or those that are eligible as historic properties, which we call Wahi Kūpuna, if there's a potential impacts of a project that is supported by federal funds or involves licensing or permitting by a federal agency, then this consultation process is triggered. And so this is where NHOs can be involved to be able to influence the decision making in a way that is pono. Other things that are closely linked to this Section 106 consultation process is NEPA, and that is the National Environmental Policy Act. So this law basically requires the production of environmental assessments and environmental impact statements for federally managed lands and for certain federal construction projects or projects that are federally funded or require certain federal permits, licenses, and leases. So very similar to the NHP, National Historic Preservation Act. And oftentimes these review processes, which require, public input, including the input of NHOs, they overlap. Yeah. So um, the federal laws provide that if there's multiple consultation requirements, then it's best to harmonize those efforts rather than duplicate them. And so, what does this mean in terms of projects that occur in Hawaii? Um, there is overlap with various Hawaii state and county regulatory frameworks. And so the companion law for NEPA is HEPA, the Hawaii Environmental Policy Act. And there's a lot of things that happen both at the county and state level that trigger the production of environmental impact statements and assessments. And so there's also the need to harmonize the federal and state frameworks. And so one important thing about HEPA is that over time there has been advocacy to ensure that cultural impacts are also analyzed within HEPA. And so we're very unique in all the 50 states that within our environmental review process is also a cultural impact assessment or CIAs. And so that gives us a unique opportunity to look at, okay, if we're looking at cultural impacts, what are certain laws that protect Native Hawaiian cultural practices? So we look to Hawaii state law through its strong constitutional safeguards of the public trust and Native rights. And we marry that with the dual responsibility of the federal government to exercise a fiduciary responsibility for the betterment of kānaka iwi. So this actually serves to elevate the consultation process, and I would argue requires something that looks more like what is afforded under the United um, Nations uh, Declaration for the Rights of Indigenous Peoples. So we call it UNDRIP or UNDRIP. So when we look at UNDRIP, there are very strong provisions in terms of how do you interact with Indigenous people. It's not just informing, yeah. It's actually consulting and getting their consent. And consent means yes or no, not okay, we're going to do them anyways. The United States has adopted the UN DRIP, is a signatory to the UN DRIP, but it tries to minimize some of the strong language of informed consent by saying we already have certain consultation processes or that are aligned with the UN DRIP. Um, what is important is you have agencies like the Advisory Council on Historic Preservation, the ACHP, that advises other federal agencies on how do you actually operationalize the UN Declaration on the Rights of Indigenous Peoples. Um, and so there's been different guidance documents that talk about what is meaningful consultation. It's kind of almost to the level of co-decision making. And then you have certain language about utilizing traditional ecological knowledge of Native peoples. Um, so there are things that are happening at the federal level to kind of ensure a more robust consultation. So as a Native Hawaiian organization, of which maybe a lot of you are part of, or you represent certain um, organizations that do malama aina or conservation kind of work, and you want to be effective in how you um, in sort of the protections or conditions you want to have imposed when there's a federal undertaking or when there's like a federally funded project that triggers certain laws like the National Environmental Policy Act and like the National Historic Preservation Act. So my intent is to kind of give you folks some tools and some handles um, to really push for a very robust consultation that looks more like informed consent. Okay, so this is where the state law overlaps. And so the easiest way to think of Native Hawaiian rights is to understand what Aina means to Kanaka and the life of Ohana on the Aina, particularly within their ahupua'a, which is a traditional land division. Uh, Typically, Hawaiian families, their extended Ohana lived, um, they typically lived within the same ahupua'a for many, many generations. A lot of times they would only move if the chief was very um, unfair, yeah, and unjust. They had the freedom of movement, but for the most part, a lot of Ohana stayed within their ahupua'a from generation to generation. And in that recognition, as Hawaii became a kingdom, they ensured that certain laws would protect the rights of native Ahupua'a tenants, or what the law called is Hua'aina. So let me begin first by just looking at what is this connection to Aina. So I've kind of cockroach or stolen some really cool slides, well, Instagram posts from Aina Momona, a Moloka'i nonprofit. And they basically are looking at what David Malo talked about, one of our premier Hawaiian scholars during the kingdom period and transition into the territory. David Malo kind of talked about Aina actually being something that you cannot separate from people. Um, so Aina is not Aina without people, and people are nothing without Aina. Um, and so the way that we fight for land, the way that we care for land, is understanding that Aina is like Ohana, is family. So David Marlowe, in this quote here, he talks about the people of old gave names to the features of the island according to what they observed and thought appropriate. There were two terms for an island, either moku or aina. It was called a moku because it was bounded by the sea, and it was called aina because it was inhabited by people. So this is profound in the fact that there's a reciprocal relationship, yeah, and there's not this sort of false dichotomy that of man and nature, and man dominating nature. Very much it's very much that olelo no ea, the land is chief, and we are its servants. Um, Ke ali'i ka aina he kaua ke kanaka. Um, and so what does that mean? When we look at Mary Covena Pukui's work in the Polynesian family system in Ka'u, she talks about Aina as being one that is your feeder. It's almost like the mama that you have that breastfed you. It's like you come from the bosom of this land. This is my feeder. This is my onehana, sands of my birth. This is where my this is where my Evie will rest, my bones will rest. So it's that intimate, that connection is that intimate. Um, and so if that is your worldview, then the way that you care for Aina is going to be real different than this so-called bundle of sticks that we see in Western property law, where you can even exclude the land from others and you can destroy it even. That's not a concept in the Hawaiian psyche. So in terms of looking at the ahupua'a, so this is a picture of different traditional land zones, yeah, or different vau. Hawaii Island being, the having features that are having additional features that you don't see on the older islands. They have things like kua kua hea, kua mauna. You got even more vowels than you usually see in the other islands. But I would say the general zones that we look at is the vowel akua, vowel kele, vowel la'au, vowel kanaka, um, and vowel kanaka, including kula lands and kai lands, into the kahakai, into the shoreline near shore fisheries. Um, One important thing that uh, Tutupukui kind of talks about is the ohana kōkula uka and the ohana kōkula kai. So the ohana kōkula uka are those families, in the extended families that live kind of in the more upper regions where they cultivate certain kinds of crops. And then the ohana kōkula kai live more along the shoreline. So they gather limu and they catch fish and they get crab and things like that. And so there has always been sort of this sharing customs amongst the Ohana Kokula Uka and the Ohana Kokula Kai. And it was my childhood living on Molokai, being born and raised here. Um, Really typical to sharing, sharing of deer meat and goat and wild pig, and then sharing of fish and limu. So we always had that, especially sharing amongst Kūpuna. And myself being raised by my grandmother, I always saw that in action, people bringing food for my tutu. Um, so, what do these vows look like? Vau is sort of that real top of the mountain, and it's sacred, sacred forested lands. And so not everybody had the right to go up there. You have to have a really good reason. And it makes sense also in an ecological way where you want to preserve that upper mountainous area and rainforest so that you can capture the rain and let that rain flow through the ahupua'a. So you had things like bird catchers, making ahu'ula or feathered capes for their ali'i. You had people gathering, one tree to make a canoe. But there were a lot of ceremonies, there were strict protocols that you had to undertake to enter these areas like the Vaukele, the Vauaku and the Vaukele or Vaunahele. And this is like the permanent cloud forest. So you have a lot of people that do are hula practitioners and they need to gather representations of laka. So it's like people who provide also certain ceremonia in this area. The areas that is kind of more accessible to the general, um, populace would be the Vaula'au and the Vaukanaka. So the Vaula'au being sort of this more lowland forest, and it looks like a natural forest, but it's actually designed. Like permaculturists call it food forest. So when you start seeing, oh, I see a ulu tree here, I see kukui trees, so it's like permanent fruiting trees and hardwoods. My colleague, who I call Dr. Ahupua, Dr. Kavika Winter, he calls Bawa'au your Home Depot, where you get your hardwoods, the things you need for construction, firewood, and, permanent fruiting trees. Then Vaukanaka has that Kulauka side and a Kulakai side. There are different habitation zones and areas where you have your sort of primary agriculture, like your lo'ikalo, your sweet potato. You have certain medicinal um, la'au lapa'au practitioners will, plant different kind of medicines, that sort of thing. And then in the Kulakai area, you have, members of the extended ohana throwing net, getting fish, getting opihi, um, gathering limu. These are where the fish ponds are as well, and sort of your reef, yeah. And so you have to understand the ahupa extends into the nearshore fishery as well. Um, and so you have different kinds of practices, like hanai ko'a, so places like Ho'okena and Miloli'i. You have families, longtime fishing families that pass, through the generations, the practice of feeding fish like opelu, and so they create things like a porridge made up of pumpkin and sweet potato and avocado and things like that. Now more modern, um, and it's to malama this this kind of fish aggregating area for a period of time, and makes the fish kind of tame and fat, and you don't use any meat because you don't want to invite predators that can also um, eat the fish that you're trying to cultivate and nurture. And then there's certain seasons where you open up the fishery first to those families that malama that care for the ko'a, and then you open it up more widely to the other ho'aina of your ahupua'a. So these traditions continue to take place. This PowerPoint will be made available to you. So there's a little YouTube video you guys can follow to just see like what the people in Ho'okena do. Uh, if you're interested in looking at that. So these, oh, I forgot this slide, sorry. So there's an understanding too that Malama is sort of like cycling out and rotating grounds and allowing for replenishment. So Tutupukui describes her community in Ka'u when inshore fishing was kapu, deep sea fishing was permitted, and vice versa. Summer was the time when the fish were most abundant, and therefore the permitted time for inshore fishing. In winter, deep sea fishing was permitted. A kapu for the inshore fishing covered also other growths in that area, the seaweed, shellfish, as well as the fish. When the kahuna had examined the inshore area and noted the condition of the animal and plant growths, and decided that they were ready for use, that is, that the new growth had had a chance to mature and become established, he so reported to the chief of the area, and the chief ended the kapu. So we kind of know these kahuna also interchangeably with konohiki. Yeah? So konohiki having expert knowledge of the various cycles of the fish and different plants and different seaweed and such. So I share this because these customs, the way that ahupua'a were managed, and the different social ecological relationships with the environment, has a lot of import when we actually look at different laws protecting Native rights. They have their basis in the unwritten customary law of um, of ancient times and our traditional land tenure system, where where the people could move freely through their ahupa to gather the things that they needed. So the Hawaiian sources of law known today under state law is Article 12, Section 7 of the Hawaii State Constitution, the Hawaii Revised Statute 7-1, known from the Kingdom time as the Kuleana Act, and the Hawaii Revised Statute 1-1, known from the Kingdom period as the Judiciary Act. And then relevant jurisprudence or different cases, Native rights cases. This is what makes up the body of Native Hawaiian rights law. Um, So they stem a lot from uh, the customary period, where everything was oral, not written down, and they stem from the kingdom, which sought to codify these customs. And then throughout the territory period, when America um, annexed Hawaii, and then made it into the 50th state, these laws from the kingdom survived into this present time. Um, so they stem from the understanding in the establishment of the first constitution of the Hawaiian Kingdom, where Kamehameha is acknowledging that he's not the one that owns private property. The islands belong to him for the management, yeah, for the chiefs and people in common, of whom Kamehameha was the head. Okay, so if you think of property law, it's like when you buy a property, you only get what you bought. You don't you it doesn't magically turn into something else. Like you buy a Volkswagen Bug, it doesn't magically turn into a Porsche. You know, you don't get more privileges than what you already have. And so if you go back and you think about the overthrow and the annexation and the Admissions Act, the US government is saying the same thing Kamehameha said. Really, we don't fully own it. We manage it in trust for the benefit of Native Hawaiians and the public. Okay, so you gotta kind of read through the language. Like, what is it really saying here? So it stems from this constitution, which acknowledges that hey, Aina cannot be dominated. Aina is Ohana. You know, we are part of that. Aina is people and land together. So you see that the origins, you know, and this stems from the Kumulipo, the Hawaiian, Hawaiian origins or cosmology, where different things are birthed during different eras or wa, and humans kind of arrive later on the scene, and so when this genealogy is chanted, you know, the chiefs being more closely linked to the akua, you understand that hey, we stem from all of creation. We're on this equal status. We're not, well, in fact, we're actually inferior. We're serving those that were born before us. So, in essence, Native Hawaiian law is founded upon these understandings under this Kanaka worldview. So, this is what Kamehameha is acknowledging. I'm not an owner, I'm a manager, and I'm doing this in trust for the chiefs and people. And so during the Mahele, when there was a privatization of the land, it turned into sort of this hybrid thing, and it was the king and the chiefs quit claiming to each other, whatever I get, you get them. Whatever I get, you get them. So they try to look at this, like Professor Daviana McGregor, she does this kind of like a rainbow cake looking thing. Like there's different layers, and they include the ali'inui or the mo'i, King Kamehameha, the ali'inui, the chiefs, and then the people. So the chiefs and the king, they said, whatever I get, you get. They said it to each other. But what we can never take out of this cake is this long-standing families that lived upon the land uh, from time immemorial, generation upon generation. Um, it's kind of like you cannot separate the flour, the egg, the sugar. Once you mix them together and you bake it, it becomes this cake. You can never turn it back to eggs, flour separately, right? So they're saying that the Maka'ainana, the common people, the whole Aina, the Ahupa tenants, they're so attached to the land, you cannot erase them. So everything you do is subject to the rights of native tenants. So there's that acknowledgement on every kind of like land, um, royal patent land deed. You're gonna see this saying reserving the rights of native tenants. So the third class being the maka'ainana. Um, you had chiefs owning like whole ahupua'a, but the people could still freely move between their ahupua'a. They could claim their kuleana, their small 1-2 acre lot that had a house and a maybe a lo'i, a taro patch and some of their garden area. Some Hawaiians, some maka'ainana elected to get their kuleana, but only was like less than 1%. But there was still sort of this understanding that the chief going to take care of us, like in the old days. So King Kamehameha was very adamant of including this Kuleana Act. Initially, it was passed in 1850, where you had to ask permission of now what's called the landlords or the konehiki, these former chiefs, um, to basically obtain certain things that were very important to everyday life, like firewood, house timber, aho cord, thatch, tea leaf, right to walk upon traverse upon the roads and traditional trails, and to gather water for drinking, so long that as it was for subsistence, not for commercial use. So you have these provisions here, and what the king said is, a little bit of allodial title being like, even if you have land in fee simple, it's nothing if you don't have these basic rights to freely move to your ahupua'a and gather these things. So this Kuleana Act survived into statehood as HRS 7-1. And then you have what's evident through these initial laws is that property in Hawaii is different. There's no right of exclusivity. So this case, PASH, Public Access Shoreline Hawaii, basically says to this developer who wants to develop a resort on Hawaii Island in Kohanaiki, it says, you're trying to say that you have the right to exclude Native Hawaiians from your land where certain customary practices are occurring. No, you don't have that right. In Hawaii, property law is different. You don't have all the bundle of sticks. So this is under Western property law, this bundle of rights or bundle of sticks, which would include the right to control or use, the right of benefit, the right of transference or to sell your land, the right to even destroy, like coal mining and quarries, and the right of exclusion, meaning you can alienate people and say no trespassing. This is where the court is saying this right of exclusion or alienation is not something that exists in Hawaii because of this understanding here with the Constitution of our early kingdom. Um, and then finally is the Judiciary Act. And so what the Judiciary Act did was instruct courts to look to English and American common law or cases for guidance, except where they conflict with Hawaiian judicial precedent or Hawaiian cases and Hawaiian custom and usage. So often I show my students this picture and I'll ask them like, what are these two men doing? And they'll say, oh, they're gathering opihi. And I'll say, is gathering opihi noted in the Kuleana Act? And they're like, no, it isn't. But is it a Hawaiian custom? And you say, yeah, it's a Hawaiian custom. So the basis of this Judiciary Act or HRS 1-1 is it's a catch-all for other Hawaiian customs like opihi picking. That we're going to recognize that Um, and why did the kingdom say we're going to look to the cases of England and America for guidance? You got to kind of think of it in a common sense way that now, Hawaii, the Hawaiian Kingdom is entering into this League of Nations. They're having these international relations, including commerce. But we never before this we didn't have a cash economy. Okay, let's look at what America and England say about contract law, you know, commerce related things. So it was seen as more of a useful thing, like don't reinvent the wheel. Let's look what these other guys are doing. But if it's gonna conflict with our custom, then our custom will trump that. So this law survived into statehood. And then you have a reaffirmation in 1978 when, in the Constitutional Convention where we're saying we're elevating Hawaiian rights, the rights of Native Ahupua'a tenants for their customarily and traditionally exercised practices for subsistence and for religious purposes. We are recognizing that as fundamental rights. So when you put something in the Constitution, they become fundamental rights. So that's the important takeaway here. Um, so we look to certain jurisprudence. Yeah. So some of that jurisprudence includes cases of okay, if we're looking at the supremacy of Hawaiian customs, what is Hawaiian custom? And so early on, the kingdom stated we always look to the kama'aina. So these are those old timers that are of that land, of that ahupua'a. We're going to ask them first. So this Ashford case is about um, a modern day surveyor trying to figure out the boundaries of a shoreline property. And essentially, the property owner wants his own private beach. And so the modern day surveyor, through his, professional, looking at the tripod and all that kind of stuff, basically gave this man a private beach. And it's an interpretation of what makekai means along the shoreline. And so the state kind of pushes back and says, no, we shouldn't be just relying on a modern day trained surveyor. We should be looking to the people of that ahupua'a and what they know to be makekai. And so when Chief Justice Richardson was still alive and he came to the law school to speak to our Native Hawaiian rights class, he said the question was, where do you park your canoe? And for us today, where you gonna put your rubber slipper when you go to the beach? And where you gonna put your beach mat? Are you gonna put it where the waves gonna wash it off? The highest wash of the waves, which the surveyor was saying. It's like, oh no, I'm gonna look for vegetation. I'm gonna look for the naupaka. So you see the canoe is parked at the vegetation line. And we're very similar in that respect of how we do things, when we go to the kahakai. And so what the court did was cite various other cases like in boundaries of Pulehunui, where at the time of the Mahele, land was described only in name, and it was up to the kingdom's land commission to figure out the boundaries, the palena, right? And so they would ask kama'aina. So if you think about in Hawaii, when somebody asks you directions, do you remember the street names? You don't, right? And you kind of throw off the tourists. You say, okay, you're gonna drive past three. You're gonna see like this three coconuts in a row, coconut trees in a row. So when you see that, you're gonna have a dirt road right after that on the right hand side. And then you're gonna drive down that dirt road, and then you're gonna look for the purple house with the pink mailbox. And that's where the guy lived. Like, and the person go, what street it is? Oh, I don't know, but just look for the tree, coconut tree. And that's how Hawaiians describe the boundaries, the palena, the markers on the land, right? So the court is saying it is not solely a question for a modern day surveyor to determine boundaries in a manner completely oblivious to the knowledge and intention of the king and old-time Kama'aina who knew the history and the names of various lands and monuments thereof. Okay, so I do this song with my students so they remember. Um, it's a Ghostbusters song. When something's strange in the neighborhood, who are you gonna call? Ghostbusters. So I sing, if you like know the Hawaiian custom, who are you gonna call? Kama'aina. Okay, so what this means is there's an establishment of Kama'aina expertise. Okay, so now let's look at this in a federal context when NHOs are being called to consult. You know, when you like know what to do with this federal project, who are you gonna call? NHOs. Okay, so the NHOs should have that expertise of that aina. You know, the customs of that place, what needs to be protected, how it should be malamad, and it's provided in the law itself. And then you have cases like Kalipi, really looking at what are the rights of native Ahupu'a tenants or Hawaiiana, and in this case, the court is saying like you gotta actually reside in the Ahupu'a where you want to gather. And it's on undeveloped lands because we're trying to balance the rights of private landowners and Hawaiians. And the right must be exercised for the purpose of practicing Native Hawaiian customs and traditions. And private landowners, you gotta bend because any argument you make for the extinguishing of traditional rights based simply upon the possible inconsistency of purported native rights with our modern system of land tenure or our modern property law, it must fail. So that was the kind of first case out of the gate that really was looking at what do these laws protect in terms of the rights of Hawaii. But you have to look at cases as a kind of mo'oku'aha, as a kind of genealogy. Yeah, so the genealogy being like, you get grandpa and then you get mahua and then you get keiki and then you get mopuna and they all look alike. He said, like for me, I'm the Bikoy family. We're all round face Filipinos. I'm half Filipino. So everybody look at my circle face and go, oh, you're a Bikoy, right? So when you have when you're looking at cases, when they say precedent, it's like a mo'okua that builds upon the other. And they're all supposed to look alike, have similar features, like, oh, I know you come from that family. All right. So, um, but each new generation kind of breaks out of the mold and they present a new challenge. So there's the challenge of the court to harmonize these cases. So Pele was about people that don't reside in this particular ahupu'a, Va'okeleo Puna, and it was slated for geothermal development. And so you have families that are in neighboring ahupu'a like Ka'u that rely on the Puna region to gather. You had people like the late um, Papa Papa Henry Awai, who was Kahuna La'au Lapa'au, gathered Hawaiian medicines. And there are certain things that only existed in Va'okeleopuna, but nobody lived there. So what the court realized was there were traditions long ago. Excuse me, to drink some water. There were traditions long ago where people from neighboring Ahupua'a would gather in the Puna region. So the court is realizing, hey, that's a customary practice. So we have to expand our thinking as we from Kalipi, where we said actual residents actually residing in that Ahupua'a. We're going to recognize that right. So what they did was expand in Pele by saying, okay, if it's the custom that people from neighboring Ahupua'a gather there, then we're going to recognize it. And this prior to 1892 language here in the second bullet point is really about the last iteration of the Judiciary Act during the Kingdom period, just before the overthrow. So it's a recognition that customs can evolve, yeah, within a society. It's not a time immemorial. Like if you did it anciently, then we'll recognize that as a customary practice. So this is where this 1892 language comes in. And then you have this case Pash that looks at native rights and customs within an ahupa on land that it's not undeveloped, but it's less than fully developed. And so it's where this resort was being proposed. And you had certain members of Pash, this group called Pash, who were kānaka, and they gathered this opai, this kind of transparent tiny shrimp in ancholine ponds, and they used that for bait for opelu. And so the court was realizing that this land is not like wild and undeveloped, but it's still less than fully developed, and we see Hawaiian practices taking place here. So now we're going to kind of expand Kalipi from this sort of undeveloped land standard, and we're going to embrace a less than fully developed uh, standard. There are other important points of this case that recognize that Native Hawaiians have unique and distinct rights that are separate from the general public, which gives them standing to intervene in certain agency decisions that impact their rights and practices. And so the court is saying here that there is this specialness of about kānaka. They have special rights that must be protected. And then it goes further to say that when we look at custom, we're going to look at it in a more fluid way. We're not going to look at it like if you practice it from ancient times, then that's a custom. It's going to be, we're not going to follow that standard. It's the 1892, prior to 1892 standard. And you don't need to continuously practice it. The court is acknowledging that, due to the overthrow and the changes in our Hawaiian land tenure system, sugar industry, different land use changes, that Hawaiian practices may have been harmed, or people couldn't continuously practice it. So the court is saying we're not going to require a continuous, uninterrupted kind of standard of exercising Hawaiian cultural practices. We're going to be more flexible here. And then, when we talk about reasonableness of the custom, is like so long as there's no good legal reason against it. And certainty is kind of like not as to the subjective needs of the developer, but it's something that should be objectively defined. And yes, there are competing interests. You got private property interests, and you got the interest of Hawaiiana, and their ahupua'a rights, the rights to their ahupua'a. The state has the authority to balance those things. to reasonably regulate native rights, but not regulate them out of existence. So those are the main factors of that case. And then we look to Kapa'akai as to, okay, we have the Constitution that protects native rights to this fundamental rights kind of level. What does that mean in terms of an agency reviewing a project, and how do we affirmatively protect native rights, knowing that we as a governmental entity have this fiduciary responsibility? And so the court here is saying, okay, one, when a project comes before you, you don't adopt their plan verbatim. If they're saying, oh, we're protecting Hawaiian practices, we're protecting the rights, see our cultural management plan, you cannot, as an agency, said, oh, that's good. Oh, okay, we've done our job, we approved the permit, which essentially happened with the Land Use Commission in the Kūpuna Resort Development proposal. And so you had this hui called Kapa'akai, and there are Native Hawaiian practitioners gathering pa'akai, the Hawaiian sea salt, and uh, gathering Pele's tears. There were burials there. There were important traditional trails. And so the court is saying the standard by which each agency must follow is, first, they have to kind of do this inventory of what get, valued cultural, historical, natural resources that are important to traditional and customary Native Hawaiian practices and rights in that subject area. And then what's the potential impact to those resources, rights, and practices? And then if there's impact, then how are you going to mitigate? Yeah, how are you going to reasonably protect Native Hawaiian rights with this project? So in a very easy way, again, pidgin Hawaiian kind way is what get, what gonna happen, and how you make them follow. What get over here? What are the resources? How Hawaiians depend on them? What gonna happen if this resort gets built? How gonna make this funnel? How am I gonna kind of harmonize this thing and make it okay for everybody? So again, as an NHO, you want to be thinking of the Kapa'akai framework. Yeah. So these are some handles you can follow. Sometimes, it's an issue of criminal law where Hawaiians are on the defense. Yeah. So we have instances like the Hanapi case where you're now the burden shifts to the kānaka who is seen as a criminal, right? So in this is a so-called criminal trespass issue. And Mr. Hanapi is trying to say, I was trying to malama this place. There was an illegal grading and grubbing, and filling of a fish pond. And I called the Army Corps of Engineers. The Army Corps of Engineers agreed there was no permit to do this, and the landowner has to restore this fish pond to its um, original look. But you have this Hanapi not trusting this landowner to do things right. So he's doing ceremonies on the land. He's doing pule. He's uh, observing the bulldozer operator, and he sees the dozer operator is trying to take the fill and put it now in a spring that feeds the fish pond. And he's like, "What are you doing, man?" And so the dozer operator says, "Get off this land. You're trespassing." And Hanapi refuses, so he gets arrested. And so what the court has created here is a three-part test. Like, first, can you prove you're Native Hawaiian? And then can you prove that what you was doing, that there's an adequate foundation to what you're doing, the claim right to a firmly rooted traditional or customary Native Hawaiian practice? And then, are you doing this practice on undeveloped or less than fully developed lands? So fortunately, in this case, Mr. Hunter P did not prevail, but it was because his lawyer didn't show up and he had to represent himself. And so he had difficulty introducing certain things into evidence. And so there was a very lean record for which the Hawaii Supreme Court had to rely on. You can't retry the case. You just got to look at the lower courts, the trial record. So this was kind of a blow, but uh, uh, it created the framework by which we look at criminal situations. So there may be issues where an NHO rep, um, has people represented within it that have had clashes with law enforcement because they're trying to malama this place. And unfortunately, that's where a lot of the arrests take place when you try to malama. Mauna Kea arrest, case in point, or trying to block the unearthing of Iwi Kupuna native Hawaiian burials. You have a lot of this sort of clash with law enforcement. And so these cases are kind of important as well, yeah, as you think about the decelerating conflict, and then and what happens when you're in a consultation situation and there's tension. So this case, Pratt, is another case where you have um, a Hawaiian kahu. His ancestral lands is the wilderness part on the Napali coast of Kauai in Kalalau Valley. And he attempts to work with the state, to the State Department of Land and Natural Resources, to go and malama this wilderness park that was his ancestral land, that is his ancestral land. And so being denied this kind of uh, uh, participation in this DLNR program, he says, I still have kuleana, I still have responsibility to take care of this place. So he goes and he cares for the heiau there. He removes rubbish in the area and invasive species, and he starts to plant vegetables and fruit trees. And the state um, the state cites him and says, you're not doing this with a camping permit, like you're staying here indefinitely, and you know, you need to get out. And so looking at the Hanapi factors, this time, unlike Hanapi, Pratt had good legal representation. And so this issue of providing an adequate foundation in the record, connecting the claim right to a firmly rooted traditional customary Native Hawaiian practice. The lawyer was prepared to bring in expertise, yeah, to talk about this cultural foundation. And so you have, again, Professor Daviana McGregor providing that expertise. And so she talks about, to be a kind of this valid cultural practitioner, you're basically fulfilling a purpose or kuleana to subsistence, religious, or cultural needs of your ohana. And you learn this practice from your kupuna. And you connected to that location, that aina, that specific aina. Um, and you were given that kuleana to care for that place. And you're not doing it for a commercial purpose. And it's consistent with other Hawaiian practices. So Dr. McGregor stated, all the things that Pratt is doing is very consistent with Hawaiian custom. And so the court acknowledged here that that is a good standard to follow to provide an adequate foundation. But despite meeting these three HANA P factors, the state looking at the Article of Section 7 of the state constitution said, but we also have a right to reasonably regulate native rights. So they were talking about things like, oh, we only get compost toilet, we have health and safety concerns, we can't have people indefinitely living in the park. We want to maintain this low density and wilderness experience. And they're saying, oh, Pratt could have gone and gone into this curatorship program. But we already know that Pratt tried to do the right thing by entering into this program with the state. So what the court stated was they found these arguments to be convincing, and the state parks is saying he could have got a camping permit. So in weighing these factors, the court kind of looks at it on a case by case basis and looking at the totality of the circumstances. And so what essentially happened was Pratt lost and the state prevailed. Um, so one of the things I've had to do was at one point train the um, National Park Service. And I kind of brought up this case and I said, look, there's a history behind national parks. You're trying to preserve this wilderness experience, but I kind of called to their attention, something that Van Jones wrote in Green Collar Economy, and he talks about, you know, before anything of an environmental movement was known, we had Native Americans taking care, such that there was such great abundance, where you could hear where squirrels could climb from tree to tree, um, at the Atlantic Ocean and reach the Mississippi River. Birds, birds, migrating, the flap of their wings sounded like thunder, and their numbers blotted out the sun. And why was that? It was because of the stewardship of the Native American tribes. And this continent was fully populated by humans long before um, Europe discovered America. Um, so he points to that history that often, it's overlooked. And then the American government began through President Theodore Roosevelt to set aside millions of acres of national forests and uh, wildlife refuges and special interest areas to the tune of 194 acres to preserve natural resources. But a part of that was sort of this passage of the Wilderness Act, and wilderness being defined as absent of humans, where man is a visitor and does not remain. So Van Jones says, this characterization reads Native Americans out of the wilderness and out of the homelands they had managed for centuries. Uh, it was basically a campaign to eliminate them and move them into reservations. National parks and wilderness areas were set aside for the benefit of white American tourists. So this sense of wilderness, and you go and look at Pratt, and it's like, oh, we want to preserve the wilderness experience and maintain low density. So you have to understand there's a bias, yeah, behind that. And I really like this quote by Luther Standing Bear and Ogulala Lakota. He said, "We did not think of the great open plains, the beautiful rolling hills, and the winding streams with tangled growth as wild. Only to the white man was nature a wilderness, and only to him was the land infested with wild animals and savage people. To us it was tame. Earth was bountiful, and we were surrounded with blessings of the great mystery." So Van Jones says, imagine if the 1964 Act had carved out an exception to allow Native Americans greater access to lands the government deemed wild. What if it had acknowledged the fact that traditional Indian lifestyles would not undermine the ecosystems but enhance them? So as NHOs, we want to be kind of looking at this issue like, is this a kind of removal and erasure of Native peoples? Is this project going to affect us in that way? Um, we need to point out the biases. Okay, so that's when you start thinking about things like traditional ecological knowledge, prior informed consent, and you need to insist on that. The state versus Palama case is the one where a Hawaiian actually prevailed, and this is a hunter uh, who has Kuleana land. He's Native Hawaiian. Um, he lives in Hanapepe Valley. His Kuleana has a taro patch. And then he goes up with his dogs and a knife up into the mountain that is privately owned, and he catches a pig, and the state cites him for trespass. Um, and so this sounds a lot like Pratt, right? But let's go to the Hanapi factors. Native Hawaiian check. Is this a Hawaiian customary practice? Is hunting? And so in this case, we have um, Hawaii Nui Akea School of Hawaiian Knowledge Dean John Osorio testifies as an expert witness, and he starts talking about, hunting pig is an act of malama aina, because often pigs will come in and mess your gardens up, including your taro patch and stuff. So when you hunt pig, it's a way to malama. And then we established too that Palamo is doing this for subsistence purposes. And so the state argued, Palamo could have gotten a hunting license and he could have hunted on public grounds. Um, why the state did not prevail in their argument is essentially if you eliminate the right of a Hawaiiana, of an ahopua tenant to practice his customary practices within his own ahopua, then you're effectively extinguishing his rights out of existence, which is against what the Pash case said. You can reasonably regulate, but if you go too far to actually extinguish that right, that customary practice, then that means government has gone too far and you violated the Constitution. And they looked to sort of the history, they looked at committee reports at the Constitutional Convention, and they found the reason why Article 12, Section 7, protecting Native rights, was put into the Constitution was because there was a lot of arrests of hunters going on private lands, trying to get food for their family. And so they say, we need to stop this. We need to honor the rights of Ahupu'a tenants. And so when we look to Hawaiian custom, what we want to do is apply some of these Ohana cultural values and customs for subsistence and malama, which Professor McGregor has provided. What does it mean to have an adequate foundation for establishing custom? You got to weigh it with other customs. So how you do that is you look at the underlying values, the ethics. And so she provides a good list here. Only take what you need, don't waste, observe the life cycles of various, animals like fish and limu and things like that. Alternate your areas to allow for replenishment. If you see depletion, then couple your own self. Don't go harvest. Let things renew over time and replant if you can. Also looking at Hawaiian knowledge itself, like the knowledge that was passed down to you from your Kūpuna and your Makua. Like you should respect that and protect it knowledge and don't carelessly give it away, especially like when it comes to where your fishing grounds are. Um, you don't just give that away to everybody because then you're gonna have people over harvesting. Um, respect your different areas. So like stay in your ahupua'a. There's certain families that fish and hunt and gather in certain areas. You don't need to be overlapping with them if that's not your ahupua'a. Be very intentional in how you gather. Understand that there's ho'ailona, there's different signs in your environment that will tell you if you should go out and gather today or not. Um, and you don't openly talk about your plans. There's a humble way, a humble, meticulous, and intentional way that you move through the aina and you move through the kai. Yeah, and it's to respect the spirits of the land, the forest, and the ocean. And there are also Hawaiians who have aumakua. They have family deities that their kino lao are certain, their body forms are certain animals. Like for my ohana, we have an akua manoa, a shark aumakua. And it's a specific shark, not all sharks, but anything of that classification of species, you don't eat them. So I cannot eat shark because I have aumakua. If your aumakua is a puhi, a specific eel, you don't eat eel. So it's respecting, the kino lao of your family deities and, ancestors that became deified as aumakua. So we're close to wrapping up. Um, so earlier on, I talked about um, the Admissions Act, the Ceded Lands Trust. So when Hawaii became the 50th state, and you have here, oh, sorry about this one, I'll fix this slide, but basically you have um, you have Section 5F granting, ceded lands, including submerged lands. So submerged lands being from the shoreline out to 3 miles. So these are considered lands that the Admission Act includes. And there's a trust applied for that for the betterment of the conditions of Native Hawaiians. So when you have trust, this issue of trust, what gets triggered is something similar, which is called the public trust. So in Hawaii, we have a very robust iteration of the public trust. It's elevated also as a constitutional provision. So um, when the federal government looks at the public trust, they defer to the states um, to interpret what that public trust is. Yeah, so this case had to do with Mono Lake, and so they defer to the state to determine what does the public trust require. Yeah, uh, and so what we know is through Article 11, Section 1, the Hawaii State Constitution, um, we're looking at conserving, and protecting Hawaii's natural beauty and all natural resources, including land, water, air, minerals, and energy sources, for the benefit of present and future generations. So when the Admissions Act was passed, right, it also conferred a responsibility on the state to seek for the betterment of the conditions of Native Hawaiians, which includes the Aina, protecting the Aina. And so there's been cases that have interpreted what is this public trust. And so the landmark case is Waihole, which was a water rights kind of case where water was being diverted from the windward side of the island to the leeward side for sugar. But as sugar phased out, the question was, um, do we return that water back to the windward side? And there were certain interests, like those building Kapolei as a city, those developer interests, and those who were claiming that, oh, now that sugar is phasing out, we're gonna do diversified ag, so we still need that water. And so they were trying to say the public trust includes commercial use, commercial uses, and the court declined that. The those these developer interests and agriculture interests were saying, commercial ag interests were saying, if we return the water back into the streams, the windward streams, and the water goes in the ocean, that's waste. And the said, no, that's not waste. Protecting the ecological integrity of these streams and estuaries is part of the public trust. And by the way, um, what this means too is that these resources are also important to Native Hawaiians. And so there were other cases like Inri Waiola on Molokai and Inri Kukui that had to do with reserved rights of Native Hawaiian homesteaders for future and foreseeable uses. And you had also Native Hawaiian cultural practitioners saying, uh, State Water Commission, if you allow this water permit um, in the amount that Molokai Ranch and Kukui Molokai are proposing, it's going to affect our estuary. It's going to affect our limu, our fishing, and our crab grounds. And then it's also going to affect Hawaiian homesteaders for their future needs. So the court agreed and said, look, Hawaiian reserving water for Hawaiians is an important public trust purpose. Respecting the resources that Native Hawaiians rely on for their traditional and customary practices is a public trust purpose. So what that indicates is that Article 12, Section 7, and all the Native Hawaiian rights cases, they receive double protection because they're also protected under the public trust. So I'll end with an example of how we tie it all together. When we look at federal actions that may affect Hawaiian rights and practices. So I belong to the Kia'ikala Law Network. And in 2017, my students and I, through our Native Hawaiian Rights Clinic, where we work directly with Native Hawaiian clients, we help these two women, Kealoha Pishora and Roxanne Stewart, who's now Roxanne Kili'ikipikane o Kolohaka. They started these like Aloha Kanaloa cultural festivals to give people an awareness of Akua Kanaloa and their various kino law, their various body forms of the ocean god. So it's dolphins, whales, turtles, um, the stingrays and manta rays. These are various kino law Kanaloa. And they worked a lot with NOAA, the federal agency, in um, strandings of these kanaloa. So this is Milo Li'i, and they're transporting, NOAA is transporting Waikini, the name of this dolphin that the people in Milo Li'i name Waikini. And so Kealoha and Roxy, they're a part of the stranding response team. And oftentimes there's a clash, like the federal government will put like this caution, this caution, danger kind of crime scene kind of tape, and they don't necessarily allow Kanaka to interact with the Kanaloa and perform certain ceremonies. So what Kilo and Roxy did was assist Noah in understanding certain Hawaiian protocols and saying we can coexist here, And so what they did was when they when they met with Miloli'i community, they said, we will malama this dolphin, this night will you give us permission to do that? and we will perform the cultural protocols that are necessary for the care of this kanaloa. And so what they did was act as a liaison, between Hawaiian community and the federal agency. And so the Miloli'i folks said, okay, yes, take the dolphin. And so, Roxy describes how the vet is measuring the heartbeat and the vitals of this dolphin as the dolphin is being transported, to this Po'olamau, this cetacean rehabilitation facility. And as Kealoha and Roxy are doing their oli, and explaining to the Kanaloa, we are now, driving through the Levalani area into the Vauakua, and then we will be arriving to Puolamau. The vet said, "Oh, the heartbeat is stabilized, not racing anymore." And so, what they found was the involvement, yeah, of these kānaka in the process of the stranding response and caring for injured and sick cetaceans, that it was a benefit, So what happened later, though, the things were kind of soured between this agency over the care of this uh, Blainesville beaked whale that stranded on the coast of Maui, and so Roxy and Kealoha were caring for this, for Kamaui, this is the name of this whale. Um, and they were doing a lot of scientific experiments on Kamaui, and then Noah, after getting all their research, kind of said, we should euthanize this whale. There's no hope for this whale. But to to those who are Kanaloa practitioners, they said you cannot euthanize the Kanaloa. They are Akua. They came before us in the Kumulipo, and they chanted us into existence, into the ao. So they're Kūpuna and they're Akua, and we don't euthanize them. We don't take away their choice. And so they can heal themselves or they can choose to wahala into po. But we should not take that away from them. So what happened in this instance is these cetaceans are sentient beings, and so Kamaui knew that they were going to euthanize him, and so he actually committed suicide. He swam at like high speed and rammed his head into the wall of the pool and died. And the way that his remains were treated when they did the necropsy was very disrespectful. Uh, and so it caused tension between the NOAA officials and these Kia'i. And so years later, when there was a stranding of a melon-headed whale in Kauai Harbor, Roxy and Kealoha went and responded, and the Pua case, who was from that area, um, they responded, and um, when the NOAA officials didn't show up, um, and the whale died, they buried the whale at sea, and then NOAA cited them for uh, violating the Marine Mammal Protection Act for taking this whale and transporting it in violation of the act. The transporting is usually noted as like trafficking, yeah, trafficking animal parts. But they use the burial as the justification as violating the transportation clause within the MMPA. And so these women stood to face $27,000 in fines individually and or 1 year in jail. And so they asked me and my students to assist in sort of in the Native Hawaiian rights kind of claims, yeah. So what happened basically was Um, the we came in during the appeal, so the administrative law judge for NOAA had certain compassion for Roxy and Kealoha, but they said they had to apply strict liability. Just looking, was the MMPA violated? Was the MMPA violated? And what the judge said it was, but the judge fined them $500. And what Kealoha and Roxy were concerned about is continued criminalization of Native Hawaiians, yeah, doing their religious practice. And so they asked me and my students to provide some of the arguments for their appeal. And one of it was looking at the Admissions Act and what does that require, you know. And so it got appealed one step up before the Department of Commerce, which has oversight over NOAA. Sorry, I drink water. What they found, the opinion of the Assistant Secretary of Commerce was that the administrative law judge Erd basically committed error in saying that they could only look at the MMPA. And instead, what it said is it remanded it back to NOAA, stating that it must also look at RFRA, the Religious Freedom Restoration Act, and it must look at what the obligations of the Admissions Act require. So, seeing that NOAA decided to withdraw the case, and so it didn't go further than that, but it did pave the way for NOAA to work cooperatively with Roxy and Kealoha. And so I continued to work with them, and we formed the Kia'i Kanaloa network. And so it was like you cannot be alone just on Hawaii Island. We know that there's Kanaloa practitioners on other islands, and we need to form a Native Hawaiian organization so that we can be consulted with, and not feel like we're alone in this. And so it's been several years, but now I believe we are officially an NHO. So that concludes my presentation, and I'm happy to entertain any questions and hear any of your comments.
Mahalo nui, Malia.
Very welcome. Thank you for all the hearts. I see a lot of hearts. Thank you.
Folks, if you have questions, feel free to unmute yourselves and share or drop them in the chat. If multiple questions come up at once, we'll be capturing some of the questions, and so we can save them and give them to Malia after folks get done asking their Nina. Malia, as we discussed, we have some questions prepped. We're going to change those a little bit and ask them directly to you, if that's my ka'i.
Sure.
Yeah, and mahalo nui for sharing your experience under the NHO Papale with that last bit that you shared. We were wondering if you could talk with the audience about maybe tools and resources that you've found especially useful as someone in an NHO who works with folks in the community on the ground in NHOs, and where those tools and resources might live.
I found a lot of some uh, before before Trump came in, there was a lot of executive orders on traditional ecological knowledge. I'm not sure if they still have survived, but I use them as tools, and they honor traditional ecological knowledge and greater parity, equal footing in the way that NHOs are consulted and part of the decision making. I find also the ACHP, the Council for Historic Preservation, they put out a lot of documents, yeah, guidance documents on how do you actually um, comply with certain consultation requirements affecting Wahi Kūpuna. So I use that as tools. There's a lot of documents that Native American tribes have put out, as well as Native Hawaiian kind of cultural working groups on how do you analyze certain things. I know there was like a Native Hawaiian committee under um, the Humpback Whale Sanctuary Advisory Council that provided good documentation. You have, I think it's called Bulletin, I forget what number, the Bulletin 15, but the National Park Service puts out resources to. I haven't talked about this in this presentation because I'm going to talk about it in another presentation, but looking at traditional cultural properties and traditional cultural landscapes. Um, actually, Julio Paul put out an excellent application for the Mauna Kea designation, and it was successful in a traditional cultural properties for Mauna Kea. Yeah. So what TCPs or traditional cultural properties do is affords is looking at Wahi Kupuna in a larger context rather than looking at just site specific. It's looking at the whole thing and and it's looking at the pilina that people have with that place. And so it affords a more comprehensive way of managing and way of protecting places, yeah. Beyond just this is a historic site and let's just build around the historic site without realizing like it's part of a greater contiguous whole. Um, so I think that application that Julio Paul put out is excellent because it analyzes the akuas, the different deities, the presence of different deities uh, associated with Mauna Kea. What is their couple? What is their sacredness? How do you preserve that? How does that inform the kanawai, the law and policies around how you manage? Um, it also follows all the format, all the criteria of how you designate a traditional cultural property uh, from that indigenous lens. Yeah, and so the power that NHOs have is having that expertise. Yeah, who you gonna call Kamaaina, right? Who you gonna call NHO? So it's there has to be a realization that your knowledge is in, like absolutely critical. Yeah, and so what you do is you utilize the law and you kind of huli it, yeah, with your knowledge, or you amplify it because you have this knowledge. It's a marriage of the understanding the law and the marriage of your traditional knowledge, customs, and practices. And then you bring them together and you amplify them and you make it more impactful. Yeah.
Mahalo, Malia. I wonder if anybody would like to ask any questions, as long as we have Malia as a captive audience for the next 14 minutes.
Aloha, this is Helen Wong Smith. Mahalo so much, Malia. I really appreciate um, your sharing your decades of advocacy and guidance. As an archivist, my concern is always um, preserving the records of the NHOs. You know, all the court proceedings can be captured through other means. But to me, to show the kind of work that the NHOs and the individuals had to go through in order to achieve things has a lot of wealth in that. And this is why Halealoha Ayao had asked me to help um, archive his 30 plus years of Hui Malama records. Do you feel that most NHOs would be open to having their efforts preserved and accessible by other NHOs? Or do you feel that that's none of anybody else's business?
I think it's a powerful tool. I mean, specific to Hui Malama, right? I don't see it anymore, but when I started to teach my historic preservation law class, I found this website that had like summaries of different issues like the Kalina Valvai, for example, these footsteps that were of missionary boots that were embedded in the sandstone on Molokai. And the Bishop Museum had like taken these footsteps, right? And there was efforts to repatriate it back to Molokai. And so it got repatriated but on loan by Bishop Museum. But the Molokai people like cemented into an ahu the footsteps. And it was a prophecy that these people that with these footsteps, which was the boot step, were gonna come to Hawaii and alter everything, you know. So the issue went before the NAGPRA review committee, and the issue was whether it was cultural patrimony. It's something that's so important to the whole Hawaiian culture as a whole, rather than owned by one individual. It was kind of a draw, like the NAGPRA committee said, "Oh, you guys need to talk story more, Bishop Museum." But I use that as an example for my students to understand what is cultural patrimony. But I can't find it anymore. So to me, like when you have information of the long history of an NHO, it provides guidance and lessons for the rest of us. Yeah, but if that long years of fighting is not recorded and accessible to future generations, then they're not gonna know how to fight. They're not gonna know how to advocate. So I'll just pose that as one example. Of course, you gotta worry about things like intellectual property, but I think it's important to kind of figure out protocols. And I think we can, like working with Native Hawaiian librarians, that think about the mana of our Ike Hawaii and how do you protect that mana, and some things should only be accessible to certain people. But I think if you figure that part out, or we as a collective figure that part out, but still provide that lessons, those valuable lessons for leadership and advocacy and protection, I think that's absolutely vital. Yeah.
Mahalo. Just to assure everyone that when we digitized the records and made it available, I did incorporate several levels of access. So some things are available to all public access, some are only to the ohana, some things are only to the members of um, Halealoha and his crew. So we're certainly not going to share GPS coordinates of where something was reinterred. So, it can be done. Mahalo.
You're welcome. I'm looking at Wainani Traub's question. I feel you. It's an uphill battle when it comes to trying to uphold um, and enforce sort of this informed consent. I can only speak from what we've had to do on Molokai. Um, we have very strong activists, and we pretty much in your face all the time until you relent, you know. So it requires like organizing and not just being you alone doing it. So we should try and organize coalitions. Um, we should figure out a way to support each other in this work. But every victory that each of us achieves individually adds to the collective. Um, so yeah, it requires being in your face a lot, and maybe working with bulldog lawyers, bulldog tree hugging, uh, you know, kānaka kind of attorneys can help too. Yeah.
Any other questions for Malia? Okay, mahalo nui, folks. I think we're going to close out then. I'm just going to announce our next, excuse me, part of this series, which is a talk by Malia on March 21st, 2026, which is super far away, but we had to get into her calendar. We've actually plotted it out for the next couple of years. So we have kind of a constant stream of these sessions planned over the course of the next 5 years. These are the next two. And just mahalo nui, everybody, for coming. And mahalo nui, especially Malia, for working with us to get this information out to folks.
My
Mahalo.
pleasure. Thank you.
Mahalo nui for joining. Mahalo nui, Malia, Helen, Wainani for your questions. I know as people log off, I just wanted to add and just emphasize that for our Kali'o Kapa'akai Collective, this is a toolkit series. And what we mean when we say that the toolkit is that we've been doing this series for a few years now. And in addition to holding space for these types of workshops and presentations, we also want to create tangible resources for community use coming out of there. So if you go to our Kali'o Kapa'akai collective website, actually right now we have two toolkits ready, one of them being on traditional cultural properties, as Malia was mentioning earlier, and the other on a Kapa'akai analysis. So keep an eye out for the toolkits that will be coming out of these workshops and presentations as well. But just mahalo nui again for your time and for sitting with us today.